I will be skipping that.
Yeah, well, I think it was done even before this thing.
Okay, guys, we got 10. So that's the 10 invites. And then whoever joins from Facebook joins. I recorded it. Okay, so we are officially live. We are recording. We have, do you go by Karina or Joy?
I go by Joy.
Okay, so we have Joy Mattingly, Jeremy Zubkoff, and then a whole group of people that are taking a class on how to buy and remodel and resell foreclosures at the judicial foreclosure auction. Originally, it was an 8-class in-person weekly meeting, and then COVID hit, so it turned into a kind of bi-weekly or so. And now we've gone to virtual for at least the next 2 meetings. So that being said, the topics that we're going to go over tonight, I'm going to go through the list now. We're going to do our best to keep it under an hour and a half, and then do 30 minutes of Q&A. Here we go. So what we're going to go through is the following. The most common issues that arise from foreclosure sales with regards to condo and HOA back dues. I want to hear both sides of this. Now, Joy is on the side of typically the HOAs, meaning she's my adversary in a lot of these cases. I'll buy something and I see her name on the docket as the representative of the association. And now I have to either negotiate or read through the documents of her association to see what I owe or don't owe. And Jeremy, our other guest attorney tonight, is also an expert on condo and HOA law. He very often represents me as a third-party bidder. And at the same time, he represents quite a few homeowners associations. So it'll be an interesting thing to hear both perspectives. We're then going to get into a little bit, not a whole lot, because it's really not a thriving business much, anymore, is the purchasing and resale of HOA liens, meaning if some homeowner does not pay their homeowner's dues and they accrue a substantial back due balance on their homeowners association dues, I've seen associations foreclose on them. And I've purchased homes for the craziest of reasons, including somebody not pressure washing their roof. And I could tell stories about the home in the Oaks of Boca that was worth $1.5 million that I paid $400,000 for because a homeowner didn't pressure wash their roof for a year and the association foreclosed on them. We're going to go through the statute of limitations, meaning if you purchase a home at auction, what's the worst case scenario for how you could get caught up in owing back to association dues? And this is not intended to be who's right, who's wrong. It's to hear both sides of, hey, when you're represented as a purchaser, this is what your attorney is going to fight for. And yet at the same time, an association is going to be representing their client and trying to get as much for them as possible. Number 4 is going to be the liability you take on as a third-party bidder when buying at the associate or when buying any foreclosure sale. And guys, I'll tell you, that's where I've seen investors go and lose everything. We learned on the last class how to never buy a second mortgage, right? Because that's the number one way to lose all your money, is not buying a first mortgage position. But I've also seen people buy $90,000 homes with $160,000 owed to the HOA and lose their asses on it. And I'm going to show you how that can happen and how to hopefully prevent that from happening to you. We'll go through some of the magic language that you're going to look for when reading through homeowners association documents. There's something called Kaufman language, and Jeremy's going to get into that and explain what it is, why it's important to us, and why it's also important to people like Joy who are revising their clients' docs to better represent them and better enforce their docs. And the last thing is being an investor, how to approach an HOA. I could tell you approaching the homeowner association and condo association is probably 80% of the battle. If you come at them as adversarial and combative, as We all know there's a few investors in this business that do. They win a lot of cases, but I could tell you that when they call those attorneys on the other side, their phone calls are not answered. It always ends in a battle in court. They win some, they lose some, but their reputation is in the gutter. And I try to tell you guys, in this business, and especially in this aspect of the business, your reputation is so important, because you're going to at some point progress on to bigger and better things. Like, I'm now building houses. And I'll tell you, they interviewed numerous builders and said, I want 10 references. And when I was able to give 10 references in the house I just built in Boca Falls, that buyer was so impressed right away, they signed a contract with us. So don't think about the now, think about 5, 10, 15 years from now. What are you building now? What relationships are you forging now to benefit you down the road? And then we'll open up to Q&A, which I didn't know how to set this up to Q&A other than it's open forum. So I'll call out a name that has a question, you'll ask it, and whoever the respondent is will respond. Okay? Everybody hears me loud and clear? Right? Alex? Good? Okay. So, welcome, everybody. Joy, Jeremy, J&J. Thank you for giving us the time this evening to put this together. And we'll start off with the most common issues that arise from foreclosure sales with regarding back dues to an HOA or a condo, and understand the difference between an HOA, homeowners association, and a condo. They are very different. Jeremy, you want to start off with this?
Yeah, well, that's really the most important thing to pay attention to is it a condo or is it an HOA? Because there's a whole different set of laws that apply to each one of them. And condos have been going on since the 60s. So you'll have declarations of condominium that go back for a very long time. HOAs really only came into existence, at least from a statutory standpoint, in the 90s. So again, it's really important to know what you're buying, because there's oftentimes the amount of money that's owed for a condo is going to be different for an HOA. Not only the numbers typically are higher, but the right to go back is often much greater in a condo association than an HOA.
Okay. And now, do we want to discuss the two statutes, 718 and 720? You want to just give a 2-minute description of each one?
All right. So the HOA Act is Chapter 720, and that's what I mentioned started coming in the 90s. That kind of the way an HOA is, you typically own your parcel, your property, and you're responsible for your place. A condo is more of a communal living, so that's under Chapter 718. So you got to understand you're sharing that space with everybody else. So oftentimes, for example, roofs and walls, sometimes windows, they could be the condo association's responsibility. So knowing what you're buying is a huge, huge item. But as Marshall was telling you, the amount of money that's owed to a condo association is governed by one of two things: either the declaration of condominium, and there's a real simple way to find the declaration of condominium, at least the first version. You look at the legal description of this property. So that'll be in that judgment that you're looking at. It'll say condominium number, your unit number blank of the association according to the declaration of condominium, and it'll give you the book and page number of the original declaration of condominium. And that's really a great place for you to start looking as to what you're actually buying. The second thing you need to be aware of is what Chapter 718 says, and that would be governed by Chapter 718, Section 116, and whether that applies or 718, 116 applies, or whether the declaration of condominium applies, depends on the language of the declaration of condominium. So what you also got to understand is declaration of condominiums, they change. All you need is a vote of the unit owners to change it. So something may have been in the books for 40 years. If they have the right vote, they can amend those documents. So you not only have to look for the original declaration, you have to look up all the specific amendments.
Okay. And this is, guys, take notes. Now, we're recording the meeting, so you can always go back and watch it again, but also take really detailed notes on this stuff. Jeremy, I want to take 2 minutes to talk about a recent occurrence that we had, which was an HOA violating the law by not allowing me through the gate to a property that I purchased. And I know this is not the most common, but it's not the first time it's happened to me. So when you purchase a property at auction, and the first thing you do is get your certificate of sale or title, and you get to the guard gate and you show it to the guard, and they say, hang on, I got to call management. And management says, you owe $26,210. We're not letting you through the gate until you pay us. What do you suggest a third-party bidder does?
Well, first of all, educating yourself on what the law actually says. That's going to be a very important thing for you to know. And this is true for both condos and HOAs. They do not have the right to prohibit ingress or egress for you to come or go to the property that you own. But what do I suggest you do? You give them the information that they need. They need to know that you're the owner and how you're connected to this property. A lot of you are going to be buying these probably through LLCs or trusts. They need to know that you are the representative of this owner. So giving them the information that they need to give you access is very, very important.
Okay, so the documents that a third-party bidder should always bring with them. And guys, sometimes I'm driving up to West Palm Beach, Jupiter, and I'm showing up to these communities, and all I have is my phone with me. Go to a FedEx Kinko's, print it out, and bring out which forms?
Well, what you need to bring is your certificate of title and your documents for your LLC, for your trust. But what I would suggest is don't show up out of the blue, just all of a sudden one day, demand to be let in. Reach out to them before you go out there. Let them know that you're coming in. Email them the documents. Create a record that you're giving them this information before you get there. Because that way the security guard already has that information. They're expecting you to come and they're not going to be surprised. So having those documents with you and sending them ahead of time is certainly helpful.
Gotcha. Okay, thank you. And guys, also, I have a note from Alex here. If you're not speaking, please silence or mute your Zoom meeting. I muted you, David. There was some weird noise coming out from his computer. All right, so now, Joy, you there?
I am here.
Okay, you're not muted.
No, I muted myself.
So I'll start off with a story, and then I want to get your input on this, right? All of my crazy experiences and over 1,300 acquisitions and resales in South Florida have led me to God knows how many unique scenarios. But one trick, and I want the group who pays to be part of this class to write this down and remember this trick, because this is going to benefit you guys. And then you're going to hear from the other side, Joy's perspective on what happens next. When I buy a home at auction, the first thing I do is track down who the association's attorney is. Very often, it's somebody from Joy's firm. I'm going to say 25% of the time, right? Give or take. You probably represent 25% of the large associations out there in Palm Beach County. So I send a very nice email, and this is actually how I met Joy, was doing this. Hi, Ms. Mattingly, I see you represent so-and-so association. I'm the third-party purchaser at auction. Attaches my certificate of sale. And if it's at a later time, my certificate of title. I'm hereby requesting, pursuant to the statute, which is either 718 or 720, a ledger for the unit of which I purchased. What that's asking for is how much money do I owe the association? Now, Joy, I want you to take it from here as far as how would you interpret that? How would you respond, and how would you suggest that investors, third-party bidders, go about trying to obtain the amount of back dues after purchasing a unit?
So that's a really good tactic because it shows a few things. One, you're interested in establishing a relationship with the association that you just purchased the property in, and that you're trying to rectify any issue with past due assessments. We can't legally advise you as to how much is owed until you actually take title. And so my response, if you weren't able to provide me with the title, or if it had not issued yet, would be that, you know, I thank you for reaching out. Once the certificate of title issues, then I'll be able to provide you with the amounts that are owed. And then at that point, I would notify the client, most likely, that, you had taken, or you were going to take title to the property in the association, and ask them, for an updated ledger so we could start down that road. But, assuming that you had taken title and had given me the certificate of title, then I would provide you with a payoff letter for the amount that was owed on the property and the amount that the client was seeking.
Okay. And that's just so you guys understand, creating this rapport with the other side of the transaction is so integral. Hang on one second. I have another person who wants to join, and I'm sending them.
All right, I'll take over for a second, Marshall. Yeah, I got to agree with Marshall. The first communication is going to be very important. Like Joyce was saying, you need to let them know who you are, and giving a copy of the title is certainly useful. But aside from finding out how much money is owed, having a good report helps. For example, when you're buying this is a good chance you bid over the judgment amount. There may be surplus money. If there's money owed on this one, you want to have a good report to say, hey, Joy, why don't you go put a claim in for that surplus? It's not something she has to do. The association doesn't have to put that claim in there. But when you have a good working relationship with whoever the attorney is for the association, they're more inclined to work with you and to try to make things work out better in the long run for the association and for the new owner.
Yeah. So, Jeremy, maybe you want to, sorry, someone else again. Maybe you want to elaborate on that just a little bit. So you send this nice email to whoever the association's attorney is. Let's backtrack for the newer investors that are tuned in. How do they find out who represents the association?
Well, it's oftentimes as simple as just looking at the court docket that you're actually buying this property in, because almost every single time the association will have been named as a party. And if they're not there, it sounds like it was what one of your earlier meetings may have been. There's a good chance it's the second mortgage, because it's rare that you would have a first mortgage that was foreclosing that didn't name the association. So just looking at the case docket, looking at any of the pleadings on the court docket, you look at the certificate of service to figure out who the attorney was for the association. If it's not there, there's another good place to at least start looking. Go to Sunbiz. Go look at the name of the association. A good percentage of the time, the attorney's gonna be the registered agent. And if you can't even find it, then there's a third place that I look. I go to the recorder's office, and I'll put the name of the association, and you'll see if maybe they'll have done a lien in the last year or so. And that lien will typically tell you who the association's attorney is as well. And it could be not only a lien on this unit, it could be a lien on any unit.
Good point. And really, guys, this is huge, really valuable information from both ends. Now, Jeremy, you briefly touched upon something called surplus. While some of the more sophisticated investors are very familiar with this term, I want you to give them 1-minute summary explaining what surplus is and why it's so important to have a good relationship with someone like Joy on the other side when there is a surplus.
Okay. A surplus is extra money after the judgment has been paid. Let's say your judgment is $100,000, but you as a successful bidder, you bid $150,000. So that $100,000 goes to the plaintiff, whether it's the bank or whoever was doing the foreclosure. The rest of the money is still in the court registry, and you have a time frame to put a claim into it. And any of the defendants to that case can actually put a claim in for that money. And the judge is supposed to adjudicate, of those people that put the claim in for the money, who is it that is actually entitled to it, whether it be an owner, the previous owner, the association, a second mortgage, a judgment holder, any of those type of defendants put a claim in there. You know, a condo association could put a claim in, and most of the time they'll get their money. Not every time. Sometimes a second mortgage may be superior to a condo association. So sometimes associations don't put claims in. Sometimes they don't really need to. You as an owner, new owner, may be jointly responsible with the prior owner for everything that comes due. So why spend money on an attorney to go get money from the court registry, or maybe get money from the court registry, when you are on the hook for it? So having that good rapport with the lawyer for the association certainly helps, and trying to nudging them to go put a claim in for that money.
And it also, guys, it saves you money. I can tell you, that I have two options when I buy, and I'll give you a real life example. I just had one yesterday via Lago, $127,000 surplus, of which $124,000 went to the homeowners association. It was a big HOA balance, late fees, penalties, interest, attorney's fees accrued over a 10-year period. And the association motioned for it, and they got every single penny of the surplus allocated to them. Now, I called the attorney on the other end, Shelley Connick, on that particular case. And I said, hey, listen, we've had a great rapport over the years. Shelley, can you please motion for me to get the surplus on this? No problem. We've got it covered. She sends me an email confirming, yes, I'm going to go and motion for it. Not only am I happy because now I didn't have to pay an attorney to go and try to get that surplus for the association, which, by the way, you as a third-party bidder, guys, you are not entitled to any of that surplus. It's not money for you. It's money intended for debtors to that parcel. So they got not only the back due HOA, but they got their late fees, penalties, interest, attorney's fees, you name it. They got every single bit of it. And I can tell you that had a bank taken back this property, there's something called safe harbor law. The association would have gotten $8,000, okay? Had I taken the property back and not encouraged the association to get the surplus, they would have gotten $24,000, which is the statutory limit. And we'll get into that in our next question on what they legally could have collected. So my worst case scenario was the 24, not the 124,000. So you build relationships with the homeowners associations, with opposing counsel, who now becomes your partner in theory. And at the same time, very often these homeowners who don't know what they're going to potentially be liable for, when that surplus goes to pay off their debtors, they're in theory paying off their own debts. So somebody's not going to come after them at a later time for those debts. Is there anything else either one of you want to add to that about surplus?
I would just say, I'm sorry, I was just going to say that that's a great idea. One, if the association attorney isn't going after surplus, which doesn't make a lot of sense to me, even if, as Jeremy was saying, sometimes there's a question as to whether or not there's a second mortgage that's superior, a lot of times associations, most of the time, in my experience, are very successful in getting that money. And also, which is leading into probably what you were talking about for your next question, there are amounts that the association can recover from surplus that it might not be able to recover from a third-party purchaser, even if that third-party purchaser is jointly and severally liable for all of the past due assessments. So it's certainly, helping the association, and that can, go a ways towards helping foster and cement that relationship as well.
Yep. So for instance, guys, just so to summarize it, if Joy's firm represents a client in, let's just say, Boynton Beach Condo Association that's owed $100,000, if I buy it, I'm protected by the statute of limitations, 5 years. If a bank takes it back, they're protected by what's called safe harbor. But if we work together, the association can now get anything they want legally as far as late fees, penalties, interest, attorney's fees, all that. So technically, who would have typically been my adversary has now become my partner, in the sense of when they win, I win. And at the same time, when I win, they win. Their law firm gets paid more. Their client gets a tremendous amount of interest and penalties. The only one that technically is the loser there would be the homeowner, but they're not losing any more than they legally owed.
Well, and what's important, and Joy was saying, it doesn't make sense for an association not to put the claim in, and I agree with her, but not every association has a competent lawyer like Joy. Some associations don't want to spend any money on lawyers, and they do not pay their lawyers to pay attention to this stuff, so they don't pay attention. So it slips through the cracks sometimes. So it really is worthwhile to figure out who that lawyer is, or who that representative is of the association, and let them know to make sure they put that claim in, because ultimately it's going to benefit you.
And now, not to get too hung up on surplus, but it's such an important aspect of this business, guys. I'm going to ask a question to Joy, and I want to know how you would respond to this. I just bought a property at auction today. This is a hypothetical. And I'm on the phone with you. I'm on Zoom with you, Joy. And I say, listen, I need you to speak to your client about motioning for the surplus. Your client, after you called them, said, we don't care. Our docs were amended. We're going to get paid anyways. Do you have a way of possibly either A, convincing your client that, hey, there's nothing to lose by doing this, or B, saying, Marshall, you pay for the suit or you pay for me to go to the hearing, and I'll gladly represent my client for the surplus?
Sure, that could happen. The second part, the way to convince the client, in my opinion, is that, so the statute says, let's just assume their documents say that you're jointly and severally liable for all the past due assessments that are owed. Doesn't say anything about the interest, the late fees, the costs, or the attorney's fees that have come due while that file has been delinquent. And in fact, there's case law that indicates that a new purchaser is only responsible for the assessments that are owed and none of those other amounts. So the client needs to go after that surplus if just to get those amounts that it can't recover from you. So if I'm going to court in the first place, why wouldn't I ask for everything that we could possibly get? So that would be my first response, is that it's usually pretty easy, and I don't have clients pushing back as to going after surplus. Again, you might have an issue where someone else is claiming superiority, and that might be a problem, but it's still something that is really worth trying. Now, if a client says, no, I don't want to do it, and then you want to, pay for us to do it, I would have to clear it with the client to make sure that they were okay with that. But other than that, that is certainly something that could work if for some reason the client was just being obstinate or unreasonable, because that would be the position that I would take. They were being obstinate or unreasonable. So,
and we, just so everyone knows, we've only had one time, 1,300 or more properties now, where an association said, our docs protect us. We're not doing anything to help you. We're not going to motion for surplus. We're going to get paid either way. What do? Can I independently, as a third-party bidder, somehow go and motion to get that surplus allocated to pay my back due HOA, which I now incurred?
So that's a question for the judge, in the sense of you would have to appear as on behalf of the association, honestly, because you're not entitled to any of it as the third-party purchaser. So, unless you're working with the association or somehow convincing the court that you're doing it on behalf of the association, then, you're not going to be entitled to that surplus.
And that's something, guys, you got to keep that in mind, because you cannot represent an HOA. You, as the new homeowner, your hands are tied when you buy these properties. And that's why these relationships are so important to have. And, to make that phone call, to be able to send that text and say, hey, I have one for you. Can you please do this, is of utmost importance. So we've spent 15 minutes discussing that. That is a really awesome topic that we'll circle back, guys, in the Q&A if you have any other questions about it. Any other input from Jeremy or Joy on that topic? No? Okay. So what other, and Joy, I'll direct the question to you. What other issues do you typically run into with third-party bidders and your end of the business, as far as someone buys a home or a condo, you represent that homeowners association or condo association? Besides back dues, what's the next most common issue?
Probably, the association is concerned about who just bought the property. We don't know anything about them. We have approval rights. Obviously they don't have approval rights over who purchases at a judicial sale. So they're already nervous about that. So, approaching either the attorney or the manager, I would go through the attorney if you could. They may direct you to the manager. And kind of just, telling them a little bit about, hey, I bought this property and I have this company and this is, what I'm intending to do. And also filling out the same paperwork that a normal buyer would buy puts them at ease, because they now have some information as to, who owns this property. You really want to check out, are there any restrictions in the association for rentals or occupancy in terms of age? Because, that's the number one thing that my 55 and older communities are worried about, is that, oh, this person purchased the property and they're only 35. Okay, well, that doesn't matter. Anyone can own the property, they can be 18. They just can't live there if you have that 55 and older occupancy rule, or there are restrictions against them living there. Let's put it that way. So, that's really the number one thing that I run into is, clients being concerned about who's bought in the association, and how do we know who this is, and will they go through the approval process? I do let them know the approval process isn't, you can't disapprove ownership, but if there's an occupancy issue, then that's something that we can address. But I would say that's probably the number one thing that they are concerned with. And then maybe the second thing would be if there are ongoing issues at the property, particularly in an HOA, there might be violations on the property. Like this may have been a property that was in foreclosure for a while. The pool may be green, the lawn may be mowed. They want to make sure that those things are going to be rectified pretty quickly.
Yeah, and that's reasonable. Now, pertaining to a few comments that came out of your mouth just now about application fees for third-party bidders and enforceability of restrictions, I know the answers, but I want everyone else to know them. So I just bought a home in an association that Kay Joy Mattingly manages, or is the attorney for. It's 55 and older. I get to the gate, they let me in. But then the neighbor, Mr. Grumpy, comes out and goes, "Hey, you can't be here. You're not 55 and older." And this is a real life, guys. This happens all the time. So he calls the security. Security comes over, and this is 9 out of 10 times when you're buying a 55 plus. And security says, "Listen, I just got a call from the management office. You have to go and get an application, fill it out, pay the $200 application fee, and get approved before you could do anything in this unit." Is that enforceable?
It depends on how far you want to push it. I don't think it's enforceable. I think that if you're going to live there, occupancy, it absolutely is enforceable. The application fee itself, I have to tell you, I haven't really faced that question about, not wanting to pay the application fee. And I don't know that that's the real issue, but you can certainly access the unit, start to fix it up under the association's guidelines, meaning if you need a permit and you need any sort of architectural review, you have to go through that. But I don't think they can make you fill out, they can't make you fill out an occupancy approval form. But what I would do, because there's no reason not to, is I would fill out the paperwork so they have your information, so they know who you are, so they can, ensure that the person that's coming in is not, doesn't have a criminal background. They don't need to worry about their other residents, that sort of thing. But they can't bar you from coming in the unit. They can't bar you from doing work in the unit. But if you, in my opinion, you're better off, filling out the paperwork at some point. But I don't think that they certainly can't bar you from accessing the unit, but they can bar you from living there if you haven't filled out the occupancy application forms. But they can't bar you from coming in.
And for those of you that want proof of what we just discussed, Google my name and Eric Nathanson, and Google HOA will not let in gate. Literally, put Eric Nathanson, guard gate, Palm Beach County, and you will see on Fox News and a few other channels syndicated throughout the United States, there was a very well-known case that we brought against an association for that exact matter, in addition to other issues. Fill out the form. Don't be that guy. Don't be the prick. Fill out everything. I can tell you, I represent third-party investors. So what I get with all of my investors, if you're going to take on outside capital and represent people, is get a POA, a power of attorney, that you can apply on behalf of that investor. So when I buy under FLRR2 LLC, I don't want my investor who's out in Silicon Valley and is a Fortune 500 CEO to have to pick up the phone and answer emails about an application for something that has nothing to do with him. I represent his investments. So get a POA, or get what's called a statement of authority, and I get that recorded publicly so that the association can see who I am. I have my driver's license, I have the POA or the statement of authority. I go right into their management office and I show them, here, this is who I am. Jeremy, you look like you want to say something about that.
Well, yeah, and I kind of went to what I said at the very beginning. Try to be forthcoming with information about who you are. Try to be helpful to them as opposed to being an obstacle. That, you know, when you're coming to be helpful, that you're more likely to get the result that you want and not as likely to have to call someone like me to go fix it once there's a problem.
Yeah. Okay, now, Joy, this is an interesting one. We had an investor who had a felony background, right? Now, he wasn't like really a bad guy, not like murder or anything. He had some stupid charge, drug possession, when he was like 19 years old. He's 65 now. But association said they wouldn't let him through the gate to access the property he bought at auction because he's a criminal. If you're at liberty to comment on this, and if you're not, I totally respect, how would you advise your client in a case like that? Third party
Really?
buys a property and he happens to be a criminal. He's not living there. He just wants to get in and remodel it.
Well, I think that, you know, a lot of this stuff is about, you know, degrees of things. So the first thing you would have to look at, you know, coming from my perspective, is what the governing documents say about restrictions for ownership, not even ownership, but occupancy. So a lot of association governing documents, you know, they limit the felony convictions, maybe the last 10 years, something like that. And then also you're going to take into consideration what the felony conviction was for. And that's for occupancy. But in terms of allowing an owner into the community, you know, with the exception of maybe, you know, some sort of sex crime that they would be violating some sort of, you know, sex, you know, restriction, you know, in terms of being close to certain people or something like that, I don't think they can bar them from entering the community in general. You know, so you really have to look at the governing documents as to what they say, because a lot of times they're silent, you know. And then if they're not silent, again, usually it limits it, but I don't know that you can limit access just because of a crime. I will say that, you know, some of my other colleagues are in the firm are more versed in this area, but obviously we all kind of see stuff that comes around, and that would be something we would definitely treat with kid gloves in terms of erring on the side of caution, meaning we would allow the person to likely access the property.
But there is a simple solution, guys. Don't invest with criminals. Then you'll be all right.
Well, I think that one of the important things you really need to pay attention to here is, again, what type of condominium are you buying in? And Joy was talking about occupancy requirements, and not every condo association or HOA has them. You're more likely to find them when you're buying in a 55 and over community.
Mm-hmm.
That's where they want to make sure that their occupants are a certain age, so they have occupancy requirements. General condos, many of them don't have any of them. HOAs are, it's even fewer to have occupancy requirements. So really know what you're getting before you get it.
And I will give everybody a fair warning. There's one type of property that I've run into consistent issues and questions, yet I've done very well in these types of properties. And I'm openly sharing this with you, and that's the country clubs, right? Country clubs are private membership clubs. They can pretty much restrict you for, I don't know, Jeremy, you tell me, for pretty much anything they want that's in their operating agreement.
Well, there's some federal laws that would prohibit them from discriminating. And there's actually even federal laws about dealing with these crimes that you were talking about before. But yeah, with the private clubs, they have a lot more restrictive rights on who can come in and own units and occupy units than most other condos or HOAs.
So to summarize this portion of the meeting is, guys, be cognizant of who your investors are, right? Not that you're dealing with bad guys, but you never know who's backing a deal. That's why I use the app, and I always default to this. I use Forewarn. Anybody that I do business with, anybody that's watching my kids, I have an app. forewarn, everybody in the club knows about it. My 120 agents that work at my firm use it. You could pull somebody's background in 10 seconds, just their name or phone number, and you'll know everything about them. And I highly advise utilizing that for people that are going to back your transactions as well. It impacts your reputation at the end of the day.
Now, one of the important things, Marshall, is that you got to understand, what is your plan for this property? Are you just planning on flipping it? Are you planning on keeping it and renting it out? Because the occupancy requirements, there's a huge difference, rental versus just you're going to resell the place. So again, that's something you're going to pay more attention to. If your plan is to hold on to this long term, does the association then have the right to tell you who you can rent it out to? Do they need approval rights for rentals? Is there age restrictions? So you really got to pay attention to that, and more so when you're planning on keeping the property as a long-term investment.
Good input. And then I'll let either one of you or both of you comment on this one. I have a note here of a very wise investor who bought a condo in an association that said no rentals, period. Right? So he took the old owner who occupied the unit, put him on the deed as a co-owner, right, as an owner, and gave him in an operating agreement 1% ownership in the condo. He now technically is an owner, not an occupant or not a renter. How would you, Jeremy, would you ever advise a client to do that? And on the other side, if you had somebody pull that fast one on you, how would you react?
Well, first of all, when you're playing games, sometimes you're going to get burned. So when you start putting someone on as an owner, they could stop you from selling a place. So I'd be very, very careful from ever doing that. Not only that, when you're actually giving somebody an interest in a property, you may be triggering a different portion of the declaration of condominium or the declaration of covenants for an HOA. You may then be triggering, instead of occupancy, you may be dealing with the sales portion. So you may just be too clever for your own good in doing that. So I would be very, very cautious about doing it. And I could tell you another way people try the same trick is not necessarily even deeding it. They will give somebody an ownership right of the LLC. They'll be a shareholder.
Correct.
And honestly, I've seen it go to court. I've seen judges that see through the plan and try to enforce it, but there's no foolproof way to deal with it. Typically, if there's rental restrictions, I would expect that a judge is going to look through any attempts to circumvent that. Not only that, the association will be able to see through it rather quickly as well.
Now, Joy, I want to hear, your firm must have been involved in quite a few of these over the years. Have you?
Well, so we see less of it than you would think. Maybe because people aren't as crafty as you would assume all the time, but it certainly is an issue. And I know I've had at least one client who has tried, or one client who's had that experience where someone has tried that. That is the issue that the person runs into that Jeremy was talking about, is that, okay, great, you managed to like add this person to the deed so they're not a tenant, but then you run into the sales provision because, so your purchase of the property didn't have to go through the normal approval process. But when you add someone to the deed, that is a change in ownership, and that typically needs to be approved by the association. Again, not always. Some associations don't have that in their governing documents, but if they have the no rental provision, then it's likely that they're going to have the other. So typically, we wind up getting in a fight, and they either back down or the client decides to take it to court, and they're usually very successful in prosecuting that.
Your client, meaning it's
Yes.
a losing battle. If you screw up at auction and you buy a property and you say, oh, I'll just rent it out till I break even, you are better off. And this is coming from a guy who's done very well, and I've also taken some substantial hits and losses. Take your losses and take them as quickly as you possibly can. Don't swim upstream is the saying as a fisherman that I use. You will be fighting an arduous battle that you will not win.
And it will be expensive for you too. All of these, you have to remember that all of these things, and sometimes it works for the owner's favor, but in this type of situation, the association is pretty much always going to prevail, and then you're going to be on the hook for prevailing party attorney's fees. So, you know, that's something to think about too. You don't want to throw good money after bad.
Yeah.
So I have a shortcut for all of you to look at if you want to figure out if there is rental restrictions in there. It's not 100% works all the time, but go look to see if your condo or HOA has ever filed a foreclosure against other people. See any of their named parties, whether it has unknown tenant as one of their defendants. If they have unknown tenant, there's a good chance that their rentals are allowed there. If you don't see that, I would certainly, dig deeper and go through the declaration of condominium and see if there are rental restrictions. Again, this is something you should be pulling up before you actually bid on these. Like I told you, you just go to the book and page number in the legal description, then look for any amendments. It's pretty quick to find them.
Yeah.
And it's 100% free. All you need to go is the county recorder's office. Palm Beach, Broward, Miami, they all have it. And it's free getting documents back to the 60s or 70s.
And you could do the same thing, guys. Go on the MLS, go under rentals, type in the name of the association, do a search for what's for rent, active, pending, and rented. And very often you will see right then and there, if there's active rentals, so I'll pick up the phone, I'll call an agent and say, hey, you know what? I see you have a rental there. Do you know much about the community? Or another trick is sort by all the sales that happened recently and see if there's a recent sale and it says no rental restrictions. That's usually something that's highlighted. Or I'll go on the MLS, I'll sort for who sold what units. And if there's one guy that sold 80% of the units, they probably know a lot about that association. I'll write down that person's number and call them and say, hey, John, I see you sell like everything in Wynwood. Can you tell me about Wynwood and what the rental restrictions are? And they'll tell you. So all these little tricks that hopefully if you get one bit of information from each discussion that we have, it can impact your career and help you. And this is one of them. We're going to move on to the next topic, all right? Okay,
Marshall, I was just going to add one other thing to the rental restrictions. There's not only complete bars to them, oftentimes there's time limits as to how long after you become an owner until you're allowed to start renting it. So you got to pay attention to both of those.
Yeah.
So, sometimes you may buy a place and inherit a renter and choose to keep them. Understand some associations will then say, well, once this renter is out, you can't rent for 2 more years. So you got to understand that as well when you're going to consider buying these units.
Yeah. Okay, our next topic or subtopic is when we purchase condo or HOA lien sales and how as a third-party investor you can profit from them, and at the same time what you need to be careful for. So, Jeremy, why don't you first explain how an HOA or lien or condo lien sale comes to fruition in the first place?
Well, typically a condo or HOA, it gets into foreclosure when they haven't paid their maintenance for a period of time. And in your case over in the Oaks that you were talking about, due to pressure washing the roof, that sounds like it was for a fine. And in an HOA, you could actually be foreclosed on it for a fine over $1,000. That's a big difference between condos and HOAs. HOA can be foreclosed on for a fine, a condo cannot. So typically, if they become delinquent in their maintenance, they have to send you, in a condo, a 30-day letter saying that they're going to record a claim of lien. And then on the HOA context, they have to give you a 45-day letter before they file their claim of lien. Once they've done that one, they then have to give you a second letter, a notice of intent to foreclose. And in the condo context, they have 30 days to do that. For an HOA, they have another 45 days. So before a condo can foreclose, it's a minimum of 60 days and 90 days for an HOA. So once that's done, they can then foreclose for any past due amount of maintenance, special assessments, and in an HOA context, a fine above $1,000.
So guys, keep that in mind. I've had numerous situations where properties were owned free and clear and homeowners either lived overseas or, God forbid, someone got sick. Something really strange happened with no mortgage on the property, and they lost the home because of maybe $4,000 in back due HOA. Or, as in this case that with the Oaks, $4,300 to the best of my memory in late fees, penalties, interest, and attorney's fees for not pressure washing their roof, okay? The homeowners association is perhaps the most powerful entity that you'll ever deal with in South Florida from a legal enforcement perspective. I could tell you that their liens trump many governmental liens. Condo liens, very often in a surplus filing, will get paid before the U.S. government gets paid. Right, Jeremy?
Well, I mean, it's interesting that you talk about this is superiority. It's a really big deal in the context of condos and HOAs. That's something, again, you really need to look at the documents. And specifically what you're looking for in those documents is what's called relation back language. Does your lien relate back to the recording of the declaration of condominium or the declaration of covenants, which was done at the very beginning of time, or the beginning of these condos or HOAs, or are they only effective from the day that they were recorded? A lot of that that'll tell you whether they're superior to different entities or not.
Yep. Okay. And now I want to also go over what to be very cautious of when you are buying association liens. And just for those of you, like I see Zach is tuned in here and David Cohen, a lot of investors back in 2009, 10, 11 would buy these condo or HOA association liens that were, let's just call it $4,000 or $5,000, right? And then they would rent out the home that they just bought. They paint it, clean it up, put some carpet, and rent it out for like 30% below fair market value. It was legal. Then a few of them got in trouble because they didn't just rent them out, but then they would fight off the mortgages from foreclosing on the units as if they were the owners or the debtors on the mortgage. And that's where they got into trouble. Jeremy, maybe you want to elaborate on this, that when you buy an HOA or condo lien sale, you don't assume the position of the borrower from a perspective of you can't fight off their bank from foreclosing on you because you want to keep your free rental income coming in. Or can you?
Well, there's certain things within limitations that you can do. You do not assume the mortgage. You're not personally obligated to pay it. However, you're buying the property subject to the mortgage, which means the mortgage still exists on the property itself, so they can foreclose on it. You know, the general adage, if it seems too good to be true, it probably is. You're never going to get this, well, not never, rarely will you get a condominium or an HOA for $4,000 at an auction and own it free and clear. That's most likely not going to happen. So you're probably buying it subject to other existing liens. So you got to be careful of that. Do you have certain rights when you do buy a unit at a condo or HOA sale? Yes, you do. You still, as an owner, have what's called the right of redemption. So you always have the right to pay off that mortgage. So you do have some rights to participate in a mortgage foreclosure or some other lien that's trying to foreclose. So you have that right. But what judges and courts don't like is dilatory delay tactics for the obvious reason to collect additional rent. Not only that, they may take that right away from you. You know, the court may appoint a receiver to go collect the rent. So while you're banking on that money coming in, the judge may very well take that away from you so you lose the incentive to keep fighting.
So that's one of the reasons, guys, that people buy these lien sales, right, is to get rental income. And it was, like I said, a lot more prevalent in 2010, 11, 12, 13. Nowadays, it's not so common, although I do see a few. And the other reason that investors will buy these is for exactly what Jeremy just touched upon, which is redemption. One of my greatest returns ever was buying, actually, it was Joy's firm that represented them. It was buying a huge back due HOA lien, like $140,000 or something in back due HOA on a house worth like $500,000. Then I took the gamble. There was a recorded mortgage from like 1991. And I didn't know what that person owed on the mortgage, but I saw it was a 30-year fix. I see there was no list pendants on the mortgage. So I figured they either paid it off, they've been paying it off, or it's pretty damn close to being paid off. We were wrong. It wasn't paid off, and it wasn't close to being paid off, but it was like 4.5 years delinquent, and they owed like 50 grand, not 450 grand. So it worked out very well for us. We had the right of redemption, meaning we went to that bank, showed them our title that said that we were now the owner because we bought the association foreclosure, paid off the $50,000 or $60,000 mortgage balance. Now we had no liens, subordinate or inferior to us, remodeled the house, and made a substantial profit on it. This is another really unique way of skinning the cat, or in this business, a very unique way of making a profit in something that most non-sophisticated investors will never even venture into. Is there any other comments? Joy, do you want to state anything about this end of the business?
It's really buyer beware. So that's what I would suggest. You know, if you are going to buy in an association, you really need to do your homework from an association sale. I mean, there are definitely association sales where there is no mortgage, you know, and in those situations, we almost always have third-party investors who purchase and the client gets paid in full. So, you know, but those are certainly not the norm in terms of, you know, it's maybe 25% of what, you know, we do. But if you're going to buy at an association foreclosure sale, you want to check out all the things that you just talked about. Is there a reported lis pendens, you know, from the mortgage? Is there a mortgage? All that kind of stuff. And then what do the association documents say? But it's definitely buyer beware.
And guys, the term caveat emptor, buyer beware, you should probably print that out and put it above your desk. This is probably the highest risk aspect of this particular end of the industry. You literally are gambling with what is owed to other subordinate lien holders when you acquire title this way. You could make a tremendous annualized return. This is also the #1 way that investors lose their asses. And I'll tell you how they lose the entire investment is. So Joy puts up a property for auction in, we'll just say, Woodfield Country Club. And it auctions off, you're the high bidder. You paid $57,000 for it. And you say, wow, I just bought a place for 57 grand. I can rent it for 10 grand a month. But what you didn't realize is that there's a first mortgage right behind Joy, who just next week is going to file their lis pendens. And in 90 days, you're going to be wiped out. Now, by the time you get into that house you just paid 60 grand for, you remodel it, you patch the roof, you find a tenant, you pay a broker a commission. You're 3 months in, you're $90,000, and you're collecting $10,000 a month for less than 2 weeks. You've now lost your entire investment because that first lien comes along, forecloses, and unless you happen to be the successful bidder at that auction for that first lien, and it financially makes sense to buy that first lien, you are toast. And that is probably the #1 place where I've seen novice investors, and it's sad, but we had one just a few months ago. Mason, who's watching right now, can tell you about it. This guy, we walk into a townhouse that we just bought at judicial foreclosure auction, and he's putting in granite countertops, stainless steel appliances, and we go, hi, who are you? Oh, I'm Mike. I just bought this place a couple months ago. Oh, Mike, nice to meet you. You just bought it. And we look on the docket and we see it was foreclosed by the association 3 months prior to the day we bought the first lien. I said, have you ever done this before? Oh, no, I've never. No, this is my first one, man. I stole it. I paid $14,000 for it, and I'm putting 60 grand in. Look at the new floors, the kitchen. He's in this thing for $75,000. I go, listen, dude, I feel so bad. I don't know what to tell you, but what you bought was just the back due HOA lien. You didn't buy the property. No, I have a title here. Look, it says I own it. I go, you owned it until this morning, because you see this certificate of sale? I just wiped you out. This is like a game of chess, and I just trampled you. You're gone. He gets an attorney. Attorney sends us a demand letter that we unfairly acquired his property. It was somewhat laughable. Mason, I'm going to unmute you for this one. But Mason ended up selling the property a couple weeks later. It was a substantial profit, and the guy got completely wiped out. I don't tell this story so that we can laugh at it. I tell you this story so that you don't become that guy. And this is why you are being trained by some of the top, most experienced agents and attorneys in this industry, so that you don't become that guy that we talk about at the next Zoom meeting in 2021, or God willing by then, in person while we're high-fiving, sharing a drink and food in 2021. Don't be that guy. Do your research. And if you don't know how, we're giving you the connections to get all the right people to do it. That's why we had Alex. And I don't know how to unmute you. Let's see. Ask to unmute. Mason, okay. You there?
I probably sold it. I don't exactly recall that encounter when you took it over though. I probably came.
It was like a mushroom-shaped townhouse in like West Palm Beach. I think you recently sold it. Could have been someone else that sold it for the firm.
I'm not sure. I don't remember that initial confrontation though.
I forget the name. There's so many. Anyways, so that's just one example, guys, of the caveat emptor. Like Joy said, buyer beware. Really be careful with this end of the business. Jeremy, Joy, any questions or comments on the lien foreclosures and anything you want to warn people about before we?
Well, yeah. So one thing to look out for in these is if it's an association foreclosing, has the association shown how much their bid is going to be? And if they do show their bid, what is their amount of bid? If they're underbidding their judgment, which happens sometimes to entice third-party buyers to come in and get it at a better price, be careful. They're giving you a sign that there may be some things that you might want to consider when you're looking at this. Not only that, if you're not paying off that full amount of the judgment, the statute doesn't care how you acquire title to these properties. You may still be jointly and severally liable with the prior owner. So I've seen associations make arguments saying, listen, you bought it for $5,000, but you know what? There was $20,000 that were owed. So you owe us the extra 15. So you may think you're getting a great deal, but you got to be really careful to pay attention. What is the amount of the judgment and what is the amount that the association is actually bidding? So
the big part you're going to circle and highlight there, guys, and I've seen this done, Addison Reserve, judgment amount, $225,000 owed to the association and club. Association attorney says, we're going to reduce it to 10 grand to get some sucker to bid, because otherwise we're wiped out by a bank next month. Bidders bid it up to $75,000, $80,000, only to find out that difference between the $80,000 they paid and the $220,000 they owed, they still owe it. They just have to now pay it at a later time after getting title. So don't think just because they reduce their bid amount, it's not like when you're buying a first lien position and the bank says, okay, we're owed 400, we'll take 200. When you're buying the lien from the association, if they reduce their bid amount or their minimum bid amount, you're still on the hook for the balance. So they didn't do you any favor of reducing their bid, right? That's the greatest summary of it.
Correct. Another thing to look for, honestly, is to do with association foreclosures. Sometimes the associations do foreclose and they've owned it for many, many years. You got to pay attention to that, because that's going to impact how much money an association could actually ask you if you do buy at a mortgage foreclosure. When you see that the association was the prior owner, you know that there was money owed, but under the law, you can only be jointly and severally liable for that time period before the association owned it, not for the time period that they owned it, or the time period that came afterwards. So it's the before and the after, not while they actually owned it.
And that's a really interesting argument. I've made that numerous times before. It usually ended for me in some type of settlement. And keep this in mind, investors, when you settle, even if the law changes later on, there's no going back. And there was a case about 5 years ago, I'd say, where we had probably millions of dollars in association dues that we had paid out over the years. And many of them, I'm going to say 50%, were settled. But the other 50%, we were able to now go back and get all that money that we paid to associations for back dues. We got it all recuperated. And again, when you settle, just understand that's it. There's no going back on that settlement. Joy, you want to add anything to that before we move on to question or topic number 4?
No, those are really good points. I totally agree about what Jeremy said. If the association has owned it for a long period of time, the statute was amended, and I can't remember the exact date, but it's been quite a while now that it was amended to indicate that if the association takes title, they're not entitled to ask a new purchaser for amounts that came due while they held title. The underbidding, definitely look out for that. It's not something that we really ever encourage our clients to do, because you are still then on the other side of it having to face a fight as to whether or not that person actually owes the money. But that is definitely something to look out for as an investor.
All right.
With respect to the underbidding, it's not only an association always trying to pull one over and say you owe more money.
Sometimes it's a
Oftentimes,
mistake.
Well, sometimes it's a mistake. Sometimes the condition of the unit is just so poor that the association wants to have nothing to do with it. So they would rather take $10,000 when they're owed 25 than own something in such poor condition subject to mortgage.
True.
But they're not giving you any deal, guys. It's the same thing as saying it's 2 for 1 or buy one, get one free. It's just a matter of how they posture it. Okay, let's move on to the next thing, which is the statute of limitations. And I don't want to spend a whole lot of time on this, but there's a few statute of limitation incidents that you will consistently run into as a third-party bidder. And the number one most common for me is when an association sends me a bill for 12 years worth of back due HOA taxes or HOA assessments, attorney's fees, etc. And I respond back with, here's what I owe you in the worst case, which is, to the best of my understanding, 5 years of back due association dues. Jeremy, why don't you start off with the answer to this? What is the absolute worst case scenario that a third party bidder could be liable for as far as accrued back due association dues?
There's no absolute answer to that, Marshall. There really isn't. While the statute of limitations for a breach of contract is 5 years, it could be more than that. There could have been intervening bankruptcies, which could have stayed the statute of limitations. For example, if someone had filed a Chapter 13 bankruptcy, it could have been in bankruptcy for 4 years. You never know what's really going on. So there could have been a stay, so it could certainly be more than 5 years. The other thing you got to understand about statute of limitations, it's a defense. It's not meant as a sword for you to say, aha, I only owe you 5 years. That only comes into play when and if they sue you. That's when you can bring that up as a defense. So, for example, let's say the association wants to say that you owe 12 years, but they never bother to sue you for it. They're going to put it on an estoppel, and you're going to be the one that's going to have to initiate this litigation. And again, it's not so simple just to say 5 years. There are many lawyers that are very, very good at this. Joy is one of them. She'll reason with her client, and you should be able to work out a deal. But just because there's a statute of limitations of 5 years does not mean that that's all you may end up paying.
Okay, now I want to throw a pointer out there, guys, and this is one that you take notes, copious notes on. I want everyone to go on the rubberstampchamp.com or any other eBay or Amazon, order a stamp if you're going to buy properties at auction, right? And the stamp is going to say the following words: paid in protest with all rights reserved, okay? And that what you're going to do with that stamp is at some point one day you're going to buy a property and you're going to be selling it and the buyer's ready to close and the association attorney is giving you one hell of a fight and they won't give in no matter what. So you have a choice. Don't sell the property and hold up the sale and potentially lose your profit, or pay them and still not give up the fight. So my famous solution is the paid in protest, all rights reserved stamp. Stamp the check, send them whatever they demand, and sue them afterwards. And I have 2 that are pending litigation right now for that exact reason. Jeremy representing me on one where it was as clear as it could possibly be that we didn't owe what they demanded, but they wouldn't give us a clear estoppel. Don't lose your deal because an attorney won't give you a clear estoppel. Pay it in protest, and then fight it afterwards. And if you're right, you're going to win. If you're not right, then screw it. Walk away from the check. Call it, the cost of doing business, and hopefully you still made a nice profit. Joy, I want to hear your perspective when you get that check from me that says paid in protest, all rights reserved.
Well, so I'm just going to say right off the bat that I would never send someone a letter demanding more than 5 years of past due assessments for multiple reasons. I do think the statute of limitations is very clear. And as I found out, to my chagrin, bankruptcy does not stay the statute of limitations. Bankruptcy stays, if an association has a lien recorded and then the owner files a bankruptcy, for instance, in a condo, the lien is only good for a year. And if someone files a bankruptcy during that year, then the lien is extended as long as the bankruptcy is filed. So if you have a lien recorded, person files bankruptcy and it goes on for 6 months, then your lien is good for an additional 6 months beyond what it would have been good for. But I will tell you, I would never send a letter to someone asking for more than 5 years of past due assessments for multiple reasons. So, you know, I think if I got a check from you that said, you know, paid in full, you know, all rights reserved, I would feel pretty comfortable with that, because I've probably taken the most conservative approach in terms of collection from you. So, but that is something that you can do, particularly because if you don't settle a case, you are entitled to, you know, get some money back if you've paid money, and then you can later show that you paid it, you know, under protest, you paid it, and you know, really didn't have to. So, but I would definitely take the position that the 5-year statute of limitations is pretty ironclad, and that's definitely our position.
And guys, that's coming from one of the most respected and experienced attorneys specializing in South Florida condo and HOA law for the adversarial side of what you're partaking in. Meaning she is your opponent from a business perspective in so many of these cases, telling you that, listen, 5 years is pretty much, we're not going after anything beyond that. Now, that doesn't mean it applies to every other law firm. And it doesn't mean that every other attorney within her firm is going to agree to that. But I could tell you 20 years of buying, selling, being in the real estate industry and counting, I've never seen anyone successfully procure more than 5 years of back due homeowners or condo dues. It's for them, that's swimming upstream, and that's probably a battle they don't want to fight. So
and even the estoppel issue, putting it on an estoppel is dangerous. You know, there are other things that you can put on an estoppel that someone has refused to pay. For instance, if you had in a condo, you have fines that someone has refused to pay and they try to sell the property. That's a good way to collect those fines, because they're kind of on the hook at that point. Somebody has to pay for them. But again, you know, I wouldn't put more than 5 years worth of assessments on an estoppel ever.
Yeah. And now,
well, I tend to agree with Joy. What I'm telling you is what I've actually seen, and people actually do it.
They
do. While we're telling you what the law should be, it doesn't mean everybody follows what Joy and I actually agree on. So, you know, I'm telling you what to be aware of, and that's when you come to a lawyer and say, hey, look what they're trying to do, and you let someone help you to deal with this.
So now let's take a real life example. Now, not a real address, not a real association as far as I know of, but let's just say David Cohen, my friend who's in the class here, just bought a home at auction. And he gets a bill from Joy Mattingly, Esquire, and it says, you owe $16,000 in back due HOA. You owe $4,000 in attorney's fees, $2,000 in interest, and $1,600 in fines and penalties. This is a homeowners association. I specifically state HOA, not condo. Jeremy, what would you advise David actually owes? Does he owe late fees, penalties, interest, and attorney's fees, or does he only owe assessments?
You know, again, what you got to understand about most of these, and for condos and HOAs, that a lot of them are controlled by the documents. So again, you got to know what the documents say, and that's the first place you're going to have to look. The answer could be you owe nothing. Very simple. That, you know, if it says that the first mortgage, anybody that buys it doesn't owe anything, and that's often that's often the case, certainly with HOAs. That's more frequent than it would be in a condo. So I would definitely take a look at that. It could be zero. It could be everything. Again, it depends on, is it a first mortgage? What do the documents say? Are you jointly and severally liable no matter what? When did the documents come into effect? Was it before or after the HOA Act? Sometimes there was HOAs that exist before the HOA Act, so you can argue that, if it's silent, that the law doesn't apply to them. And that's what we were kind of talking about, what's called Kaufman language, more so on a condo, but also applies to HOAs too. So the answer is it could be you owe everything, depending on what the documents say, but most of the time it would be limited to the actual maintenance that came due, not necessarily the attorney's fees, the late fees, or the interest. So, and I believe Joy was talking about this earlier. There are cases out there which limit liability of future owners that buy at a mortgage foreclosure to what the maintenance that was due, not the interest rate fees.
And Joy, and to the extent of you're comfortable commenting on this very sensitive topic, what do you believe you are legally, or your clients are legally entitled to in the event third-party bidder like myself buys a place, you send me this huge bill for late fees, penalties, interest, attorney's fees? What can you actually collect, or is it case by case?
Well, it's case by case, and it is by the governing documents. I'm not typically going to ask for money that I absolutely know I'm not entitled to or have an opportunity to get. And certainly not if there's any pushback. But I wouldn't ask for I do have some clients who have amended their documents, and they are entitled, their documents say they're entitled to the interest, the late fees, the cost, and the attorney's fees. I think that's a little bit of a gray area because the statute says one thing, and typically your documents can be more restrictive than the statute, meaning say that you're entitled to less than what the statute says you're entitled to, but it doesn't work the other way. You really can't say you're entitled to more than what the statute says you're entitled to. But that's a little bit of a gray area. So I would always, as an investor, push back on certainly the interest, the late fees, the cost, and the attorney's fees. And the rationale for doing that, and I think the rationale for why the courts have done this and have found this, is that you're not the person who was late, right? You're not the person who, who didn't pay the assessments and incurred that interest, those late fees, those costs, and those attorney's fees. So I think that's part of it. And so that would be my response right now, is that you look at the documents, definitely push back on the interest, the late fees, the cost, and the attorney's fees that came due before you took title, and then see if there's any other restrictions.
Awesome. And guys, that's again coming from the other side of most of your transactions that you will do. So you're hearing it from the association's number one or one of their top attorneys out there, that this is how we view things. If I selected two of the best people out there in the industry to be here tonight to give you their perspectives, because for the most part, the experienced, well-versed attorneys are going to agree with Joy and her perspective, and also with Jeremy. It's funny that we haven't seen a lot of conflicting opinions thus far, which is good. One thing I want to pick up and talk for just 1 minute about is the Kaufman language. And Jeremy, maybe you want to just summarize what that language is and why we stress reading and looking for that language in an HOA's docs.
Okay, well, it's going to be more in a condo, so I'm going to point you in that direction. What you got to understand about condos is they're basically created by the Florida statutes, by the Condominium Act. So that we call them creatures of statute. So typically statutes change, but the Declaration of Condominium is kind of like the constitution of a condominium. So what you're going to see is when this condo was formed, certain laws were in effect at that time. But then the laws change, new legislatures, new complaints, new people lobbying. So the laws change. So now your documents may conflict with what the Condo Act says. So the question is, what controls? And that comes down to this, what's magic language, the Kaufman language. And it refers to whether the documents say that it's relating to the Condo Act as amended from time to time. So is it the current Condo Act when this condominium was created, or is it the Condo Act as it gets adjusted from time to time? So those as amended from time to time is magic language as to whether you're dealing with the Condo Act from 20 years ago, 30 years ago, or today's Condo Act.
Yeah, and that magic language, guys, I have now utilized that in everything from my operating agreement with my agents at my brokerage to pretty much any long-term intent or intended long-term agreement that we partake in, as amended time to time, basically envelops. As I change things, you agree to it, right? That's in summary what the intent is when associations put that language. As we change things, you agree to abide by it.
Well, it's more as the legislature changes the Condo Act, those laws may apply to this condominium, as opposed to we are frozen in time with what the law was back then. And you know, a lot of associations don't have that language in their documents. Many do, like the ones that have the bigger law firms, like most of Joy's clients, they will get advice to amend their documents, and they typically listen to the advice. But there's a reason. If you were to come to my office, I have the Florida statutes going back 30 or 40 years. Because why? I need to go figure out what the law was in effect at the time when this condo was created. Because depending on that, depends on what rights you have. And the big part that this comes into play right now is dealing with money owed at foreclosure sales. That's the big item right now. But there was other things that the Supreme Court of Florida's had to deal with as to whether other rights that can change, like voting rights. So it's not only to do with money, but primarily the majority of the cases right now are dealing with financial side with foreclosure.
And then, Joy, I'll wrap this topic up with you. Just a generic number, if you're comfortable commenting on, what percentage of associations that you represent would you say have amended their docs?
Much fewer than need to. It's a constant struggle. You know, amending governing documents is not necessarily easy, and so there's a cost to doing it. So some associations, you know, kind of wait until they have a number of amendments to do, so they can get, you know, a whole set of revised documents, and then other associations do it piecemeal. In this particular situation, I would recommend that the client do it piecemeal and get this provision, you know, amended, because it's going to be something that most of your membership is going to want to vote for, because it's going to benefit them. Otherwise, that bad debt that they were not able to collect just goes right back into the pot in terms of everybody else having to pay for it. So it's getting a lot better. You know, this issue has kind of really only been around since, I don't know, 13, 14, I would say. Initially, even though the documents conflicted with the statute in terms of the Condominium Act, third-party purchasers were pretty much always held to be responsible for past due assessments. And then someone, you know, really took it all the way, and they got a ruling from the court that said, no, if your governing documents say a third party who purchases at a bank sale is not responsible, you could have amended your documents, and you didn't. So clearly you wanted it to be that way. So, you know, it's I would say 50%, you know, maybe more, but they definitely, it's definitely still something that you want to look for.
So guys, keep that in mind. When you're buying these foreclosure sales, there's a 50-50 shot that by retaining an attorney to just review the docs on your behalf, that you won't have to pay anything. And I can tell you that my friend Alex Sabrera, who recently purchased a condo and hired Jeremy to represent him, what was it, $26,000, got knocked down to $1,000 settlement, which technically he could have fought and paid $0. But to be a gentleman, paid the $1,000 to the attorney, and they called it a day. This is why it's so important to have the best attorneys representing you and a relationship with the best attorneys opposing you. Because at the end of the day, and I'm on my homeowners association board, believe me, we duke it out, we fight. I hate half the stuff they're doing, but at the end of the day, I'm walking my dog and we're having a conversation, sharing a beer on a Friday night. When I say adversaries or adversarial, I don't mean that they're your enemies and you hate them. It's when you're in the courtroom, you're going to fight. You step outside the courtroom, these people have, they have to be at least on a level that you can communicate and that you're comfortable with. Because I'll tell you, throughout the practice of law and my relationships with lawyers that have been prosecutors one day and then defense attorneys the next, you never know where that relationship's going to go. So don't burn the bridges. And, I'll summarize this portion of the meeting with that is treat all the association attorneys with the utmost of respect. And if you absolutely cannot stand them, which I have quite a few that I can't stand, I just don't communicate with them. But don't be adversarial with them. It gets you nowhere. If it's that bad, give it to someone to go after them. Jeremy is going after one for me right now. They wouldn't fold. We didn't owe them anything. There are so many tactics that we've gone down, and I'm not going to get into that tonight, in order to deter associations and association attorneys from trying to wrongfully collect debts. But that's not going to be the focal point of this conversation. At the same time, there are so many tactics that the associations will utilize to try to collect rightfully and wrongfully owed debts. Hopefully, from this meeting, you're going to walk away with, hey, I'm protected by this statute. I have safe harbor, or the banks have safe harbor law, and that's what gives me leverage. And all the other little things that we touched upon. And I have one, before we get into open forum Q&A, I have a little trick. Joy may not like this one, but it's okay. We're cool. I'm going to teach you guys something that I've used numerous times over the year, and it's leveraging the relationship between you as a third-party bidder and the unknown. And I say that because I'm going to openly teach you what's been one of the most profitable tricks in the industry. And this is why you pay for the class that you attend. I will buy a condo not knowing what's owed to the HOA, right? I will now have a 24-hour gap between when I won the auction and I have to pay for the property, unless it's a Friday. Now, there haven't been Friday auctions in a while, but it used to give me the entire weekend to do this. I'll then go to the association attorney and say, listen, I'm either going to walk away from my deposit of, let's just say it's a $50,000 condo, $2,500. I'll walk away from it. It's business. Or that $38,000 that you're demanding, if a bank takes it back, you're going to get 1 year of back due HOA. So you'll maybe get $5,000. I'll give you double what a bank will give you, but I will not give you the $38,000. I'm just making up a number, $38,000 that you're demanding from me. 99% of the time, the associations will say, you know what? Let's run this by the treasurer. We have 12 hours, 24 hours to decide. In the worst case, I will motion to the court for an extension to pay the balance owed. So if, let's say I call Joy, it's a Wednesday. I say, listen, I just bought this condo in Poinciana. I don't know what I owe back to HOA, and I really don't care. I paid $44,000 for it. I have a $2,000 deposit at risk. You have a lot more to lose if this goes back to a bank, or your client has a lot more to lose. So why don't you go to your client, let me know what's rightfully owed, and I will work out something over the next 24 hours with you. She goes to her client, she calls me back, hey, there's 40 grand that's owed to them. Well, if I paid 40 for the condo and I pay her 40, that's 80, and it's only worth 90, it doesn't make sense for me to go forward with the purchase. So I straight up say, listen, the bank takes it back, you're gonna get 4 grand if you're lucky. Another third party bidder takes it back, they're not gonna pay for it, they're gonna walk away from their deposit. This is gonna be this round and round, just non-stop cycle until we get nowhere. Work a deal with me. I'll pay you off a settlement now. I'll write you a check tomorrow. I'll send you a wire for 10 grand. Now I'm in it for 54. It's worth 90. I'll put 10 in, and I'll still make 15, 20,000. This is the most unique way of leveraging a relationship with an association or with an association's attorney that can, and I know Jeremy's going to have a lot of comments on this, and he wants nothing to do with this because he will go after a third party bidder and not settle on that unpaid balance. But I'm curious, Joy, what's your interpretation or your feeling of if I were to do something like that with somebody from your firm other than you?
Oh, well, you always have to approach the client with a question as to whether or not they want to settle. So that's what I would do. And I think it depends a lot on what the governing documents say again. Part of the issue here, though, is not just what the association wants to do. There's also a prohibition in the statute against forgiving assessments, And so I understand that you haven't taken title yet, but if they're forgiving assessments that you would otherwise owe, they might be in violation of the statute. So that's something that they have to consider. So there are several different, things that the client has to consider when, looking at that kind of offer. So that's what I would say. I would relay the offer, talk to them about the pros and cons, the risks, et cetera, and then see what they wanted to do.
Okay, and Jeremy, I can't wait to hear your input because I know now Jeremy represents a lot of associations, just like Joy does. So now let's remove Marshall, the third-party bidder, and put you in Joy's position of you represent the association. Go rip me a new.
All right. Well, and I've encountered this, not so much that the person went to abandon their bid after 24 hours after trying to make a good faith settlement offer. They just said, you know what? We're not going to pay you, period, even after their 24 hours is up. So they ask for extensions of time or they just default. Just because they default doesn't mean that's the end of it. The statute doesn't say you just lose your 5% deposit. It says you do lose it, but that doesn't mean that's it. I have filed motions for sanctions against people for interfering with the court process. Judges have imposed not only attorney's fees against the people that have defaulted, they could potentially require you to pay all the money. It says, if you default, yes, you lose that 5%. That doesn't mean that the case ends there. This hasn't gone up on appeal. There hasn't been many litigated files about it, but just don't think you're free and clear by walking away and losing your 5%. You might get someone aggressive like me that got it. At the worst case scenario, you now have to pay somebody to go defend you in court. And that's if you win that. You could potentially be on the hook for buying it and then owing all the attorney's fees to the association for potentially fighting it as a sanction and jointly and severally liable with the prior owner.
And now Jeremy has a very good point there, guys. No one's brought this up on appeal. I don't think anyone's ever prosecuted third-party bidders for walking away from a bid or threatening to walk away from a bid in order to negotiate another lien. I can't comment on the ethics, the legality. All I know is that it's a tactic that more sophisticated investors will utilize, and many associations are very happy to settle for 100 or 200% more than they would have gotten had it gone back to a bank, and they get a sure thing, it's settled, they know someone's going to come in, fix up the property, and move on with their lives.
Now, Marshall, Joy said something towards the beginning of this lecture, which I think is also something that I tend to agree with her on. Oftentimes, you will get people that call you at this beginning stage saying, I want to know how much money is owed. I'm the bidder. Well, most association lawyers will not give you out that information. Number one, they don't want to disclose this information to your owner. Number two, they don't want you to walk away. So it's, it really depends on what your relationship is with the lawyer. But if you call someone out of the blue saying how much is owed, good chances you're not going to get that number because the lawyer is not going to tell you.
So how would you recommend these guys that are going to start bidding at the auction, the 11 people watching, how do they find out what's owed before they bid?
Well, one thing you could do, and you should be doing for every one of these ones before you buy, is do your research on the property. Find out, is it in foreclosure with the condo or HOA? If it is, go look at the court docket. See if there's a motion for summary judgment, an affidavit of indebtedness. That'll tell you how much is owed. So if there's a lien, try to figure out the worst case scenario. Figure it hasn't been paid at all since that lien was recorded. Because oftentimes when it's in mortgage foreclosure, the owners just stop paying the condo association. So if you see there's a lien out there, just figure out your worst case scenario that they hadn't been paid since that lien was recorded. So it's just making some educated guesses with what information may be out there for you.
And I use the magic number of 60, guys, 60. You take 60, you go on the MLS, you see how much the monthly HOA is. If it's quarterly, just divide it by 3 and multiply it times 60. So if let's just say the HOA is, I'm going to make up a number, $100 per month. 60 times 100 is what the worst case scenario that you're going to owe. That's 5 years, 60 months worth of payments. If you bid with the worst case in mind every time you're bidding, you will seldom make substantial mistakes. And learn from a guy like me that as well as I've done, and I've had some really great home runs, I've had some strikeouts, and those strikeouts were painful and depressing. And at times I said, Jesus, I can't do this anymore. And there will be more strikeouts along the way, I'm sure. But I'm trying to teach you guys to mitigate your damages and not be in the position that I've been in before. And I know others watching right now have recently been in. And perhaps had they taken this class previously, or had we offered this class previously, they wouldn't have been in that position. I'd like to now open up the meeting, unless Joy or Jeremy, you have any other further comments. I want to open up to Q&A for the next 20 minutes, and then we'll wrap things up.
Well, I have one other thing to add, and this again is going to the difference between condo and HOA.
Jeremy, we can't
I want
hear
you to
you.
look for. Okay, I was saying that there's one of the differences between a condo and an HOA is the Marketable Record Title Act, and that's going to be something that's going to apply to an HOA that does not apply to a condo. So oftentimes you got to make sure whether the HOA documents have expired. If they're more than, 30 years old? That whether or not.
It depends on it depends on each parcel, honestly. So
Correct.
yeah.
So, but at least pay attention. That'll be something you're going to find in the public records. Do a record search under the name of the HOA to see whether they've revitalized their documents. I've encountered things where an HOA has come in and said, you owe, all these years of HOA dues, to which I then responded, I'm sorry, your documents have expired. You have no right to charge a lien. We don't owe anything. So it's something that, you want to pay attention to as well. That's unique to HOAs.
Marshall, can you hear me?
Double D, I see you. Yes, I hear you.
Okay, so I have a question for our highly esteemed attorneys, and this is going on currently, so I'd like to ask, and by the way, thank you both for being with us tonight. Marshall and I had agreed to do this class together.
David, we can't hear you. Can anyone hear him?
No.
David, we can't hear you. David Dweck.
Can you hear me?
Now we can.
Okay, so here's the question. I am, there's a condo association in Broward County that locked down the building in March, and I could not finish the work that I had. And to this day, they have not opened it up unless it's an emergency to get workers in there to complete the renovation. Any ammunition you can give me to fight this, or if somebody's willing to fight this on my behalf, I'm ready to take action against the association.
This is Joy. I'm sorry, I'm not touching that one with the 10-foot pole. I can tell you that if it was one of our clients, we would probably, stand behind their decision. So I probably wouldn't be much help.
Okay, well, thank you for your honesty, Joy.
Yeah.
Jeremy?
You get the same answer from me as well.
Wow.
What you got to understand from my perspective, I represent condos, HOAs, but I also do unit owner stuff.
Okay. is there an attorney that you can I'm not going to name the association, and I'm not saying I'm going to litigate, but a good, strong attorney's letter, because there's a lot of alta-cockers, aka older folks, and I understand that they're concerned, but if somebody's going to go ride in the elevator and work in the unit to finish it, that's what I'm asking to do.
All right, so David, here's what I would tell you. Call me after the Zoom call on a private number, and I may be able to help you with it then. But right now, the problem you're asking is, I don't know if it could potentially be one of my clients, it could be one of Joy's clients, so it's very difficult for us to answer that question, and you don't want to name who it is, so call me afterward, and we may be able to help you then.
Fair enough. Then I have another question regarding a completely another association altogether. You ready? Going to both of you. There was a condo board meeting that I believe violated sunshine laws, and this is a different condo association altogether, where my name in over 30 years of real estate and 2,500 transactions was slandered by a board member. I do not want to go against the board. I want to go against this individual board member. Provided that either one of you are not clients of this particular board, would anybody be interested in taking that on?
Well, again, it's something that, without knowing whether it was one of my clients, is very hard for me to tell you. But hypothetically, what I've seen other people do in situations like this, where, you know, defamation cases are often very difficult to litigate because they could be very costly, and the recovery generally is not that great, and there may or may not be prevailing party attorney's fees. Most of the time there will not be. What I've seen some people do is take their complaints like this about violation of sunshine law and go to the DBPR, the Business and Professional Relations, and have an entire
You're breaking up, Jeremy.
have complaints. Okay. I was saying you can go to the DBPR, which is the Department of Business and Professional Regulations.
Very
And
familiar.
They have an investigative division. Oftentimes, if you put a complaint in there, they will force the association to respond. So that's a whole nother thing that you could do that's very cost effective to kind of stop things that you perceive are not being done the right way.
Fair enough. Thank you for the help, and thank you for both of you for being on this program tonight.
I have to unmute. If there's anyone that wants to ask a question,
Can you hear me, Marshall?
I'm going to unmute everybody. Hold on.
Hi, David.
Unmute. Guys, you're going to get a
Hi, Dave.
notification right now in your screen that says Marshall's asking you to unmute yourself. I'm unmuting. I'm asking everyone to unmute themselves. So, okay. Who's that? Who spoke?
Dave Cohen.
David Cohen. Go ahead. You got the stage.
All right. Well, Joy, Jeremy, thank you so much for your time. It's nice to meet you. See you again, Jeremy, and nice to meet you, Joy. Hopefully, we'll be working together in the future, either side. I'm a little curious why the HOAs don't want to give an estimated. If I were to call and trying to get payoff estimate on a foreclosure, why is it so hard to get? Why do I have to get an estoppel? Is there no?
So you don't have any right to that information as an unrelated third party. So if you don't own the property, then the association is technically releasing information about someone else's debt to you, and that's prohibited. So that's why you can't really get that information from the association's attorney until you actually have title to the property.
So, Joy, is there any advice you'd give if a third-party bidder wants to find out what's owed to an association prior to a sale occurring? What would you advise them to do?
They really just need to look in the public records and see, if there's a lien recorded on the property, if there's a recorded foreclosure on the property. If they can find out your suggestion about finding out how much the assessments were, and then multiplying that by 60 or, by the quarterly, if it's quarterly, is a good suggestion. in terms of, knowing your worst case scenario. But it's not that so two things. One, the association attorney typically doesn't want to release the information because it might mean you back out of your bid. Okay, that would be one. But more importantly, they're really not allowed to give you that information until such time as you have ownership rights in that property, and you don't have ownership rights until the certificate of title issues.
So the problem I have with the 60 months is it seems like it's probably much higher than the reality of the situation. But I mean, I guess it's a safe way to do it, but you might miss out on opportunities.
Well, David, there's other places you can look to kind of reduce that time frame. One thing that, and it's certainly, this is just estimating, look at to when the default date was the mortgage was in the foreclosure. It's in the complaint. Oftentimes the condo stops getting paid right around the exact same time, a little bit before, a little bit after. So sometimes that can give you a better ballpark to estimate how much money is owed. Another thing to look for is look at who your defendants are. When you see the estate of, it's a pretty safe bet that the person stopped paying when they died. So you can figure that out. So there's ways to reduce that 60 months based upon information that you have available to you.
You guys, another little trick, David. Again, it's amazing how so much in my career, in my life, reverts to this forewarn. But I will find out the owner's, obviously their address. I'll put their name into forewarn. I'll pull them up on there and I'll call their cell phone and say, hey, this is Marshall Sklar. I'm probably going to be the successful bidder for your house. I know it's a tough question. And I know it's a tough situation, but I'll work with you if I win it. Google me. I have 900 reviews. They're all positive. I'm not going to throw you out on the street. Please just help me out and let me know, what do you owe your association? And I'm going to say 50% of the time, they don't even answer the phone. They don't get back to you. But the other 50, which is half, so the glass is half full, they say, you know what? You're the first person that actually reached out to me, and thank you. Yeah, I stopped paying I don't know, it must have been 3.5 years ago. And man, I'm not even living there anymore. I moved out last week. I heard the foreclosure sale was coming. Now you've got valuable information. You have an edge over every other bidder out there, and you just use technology to reach that person. And again, 50% of the time, they're not even going to answer or get back to you, but it's the other half, or even 30 or 10, or even if it was 5%, that it's that little edge. Because don't forget, when you're bidding on these auctions, 90% of your time is wasted, meaning if we bid on 100 homes in a week, we win 10. It's that little tiny smidge at 10% that makes the difference.
There's one other source of information that you have that you can get to derive some information from. And it's when you see that suggestion of bankruptcy in the court docket. That means that there's a good chance that they disclosed some of this information in a bankruptcy proceeding. So what you need to do is get access to a federal database called PACER. It's very inexpensive. They do charge you for the searches, but it's like 10 cents a page to do it. You can pull up that bankruptcy. You can see whether an association has put in a proof of claim, or even if the debtor has put an estimate of how much the association is actually owed in their bankruptcy petition. A whole nother source of information for you.
I posted the link to PACER. It's really cool. You could pull up bankruptcy info. You could pull up criminal cases. We've bought many homes from people that were federally indicted or in prison, and we always want to know who we're dealing with. And this website here, you pay, I think it's 10 cents a page to print it or to download it. But it's really great, especially after you've acquired a home and you know the person's in federal prison or they're indicted or something bad, or there's a bankruptcy. You could pop all the information right there. There's also Case Finder is the other one, but I would suggest going through the court system, which is PACER, like Jeremy said.
That's great information. Thank you.
Any other questions out there from anybody? No? 7:53. We got 7 minutes left to question. If anybody has any, now's the time. Or forever hold your peace. I think I've unmuted everybody. David, I just asked you to unmute. All right, I'm going to go through since we have 6 minutes, I'm going to go through a couple of notes that I put and possibly bring up another. Okay, so jointly and severally liable is the topic that I want to discuss for 5 minutes. And this is a unique approach, guys, that if you're an investor and you want to recuperate some of the monies that you've paid associations over the years, you have the right, because what jointly and severally means is basically you're married financially to that person for anything that you paid out to the association or subordinate lien holders. You technically, if you have the time and patience and willpower, can go after this person that used to own the home that you acquired and possibly collect. Or you could defer the case to a debt collector, and there's an agency that I use out of Tampa called Hunter Warfield. I give them a file, and if they collect 10 cents in the dollar settlement, I don't really give a shit because it's better than nothing. Most guys will never go after the debt that's owed by a previous homeowner whose home they acquired because that person typically foreclosed on the home because they didn't have anything. But there are people that either strategically defaulted or had temporary interruptions in their income and foreclosed, or there are people that just honestly want to make good on their debts. Now, I have never pursued these type of debts before, and perhaps somebody wants to chime in who has, but I know that there's an opportunity for third-party investors when you acquire these homes to go after the jointly and severally liable parties. Anyone want to comment on that?
Well, I think it's much easier for an association to actually do that than it would be for a third-party purchaser, because.
Jeremy, we lost you. We lost you, Jeremy. Uh-oh. Joy, do you want to comment on that?
I would agree with him that it's much easier for an association to do that. But I mean, if you have the time and the money to do it, if you're going to do that, a good thing to do is to, do an asset search on them before you start pursuing them. So whenever you are collecting money judgments against someone, you can find, publicly recorded information. What kind of car do they own? Do they own any other properties? Do they have boats or planes or something like that? But it isn't until after you actually get the judgment against them that you can require them to release financial information in terms of bank accounts and things of that nature. So, that's why it's a little bit risky to go after somebody unless you know they have assets to collect against. I think Jeremy's back.
I'm back, and to that end, a quick way to actually kind of gauge that without even running a search is you look at the summons where the person got served. Were they served in the property or were they served somewhere else? Is this an investment for them? Is it a vacation home? How many foreclosures does this person have in their record? Just because they're getting foreclosed on here doesn't mean that this was their only asset. So it's something to at least to look into. And it's something, the summons and the return of service is typically in the court file that you're already bidding on.
So guys, this is something that I don't think anyone will actually take it on, but I just had it as one of those little side notes. If we had to tie up a couple of minutes, it's a really unique perspective on the industry if you want to hire an assistant to just dedicate their time to, especially the larger delinquencies. I wouldn't go after a guy that owed $1,500 or $2,000. But if you ever had to settle an association for maybe $100,000, that may have some teeth, and it may be worth going after.
So, Marshall, there was one subject area that we kind of touched on that I, as a representative of owners, that really irritates me with some investors that they don't do, that I want to give you all a warning about. It's that approval rights of the associations at sale. And oftentimes when you look at it, they don't necessarily have the approval right. They have the right of first refusal. But what you actually need to do, according to many documents, is put that in your demand when you're telling them, hey, I want to sell this unit, and if you do not approve this guy, I want you to have to buy it. So that's something I want you to really pay attention to. And that way, if the association doesn't approve your purchaser, you then have some teeth to force that to go through. And oftentimes, by the time it's come to me, they've already missed the opportunity to do that. So pay attention to your documents and look what rights they really have. And if there's a right of first refusal, you got to demand it.
Yep. And guys, we're going to do one full circle all the way back to where we first started in this meeting. Got a couple minutes, 2 minutes left. And that is, when you acquire these properties, third-party bidders, auctions, you keep everything, every phone conversation that you have, you then follow up with an email. The same thing I tell realtors in my office. If I speak to Jeremy, I say, congratulations, your offer got accepted at $850,000. They want to close in 10 days. I'm then going to follow up, hey, Jeremy, just to confirm our recent conversation, your offer got accepted at $850,000. They want to close in 10 days. Every time you communicate with somebody involving one of these foreclosure purchases, if it's not in writing initially, you follow up with it in writing. And I'll tell you why. So many times where I've sent an email to, let's just call it ABCD Law, saying, hey, I need a ledger for 123 Southwest 10th Street. A month goes by, no response. I call them, I email them, I contact them through their website, nothing. And then I go to close and I see a bill on the estoppel for $3,500 in attorney's fees because they say, oh, well, you never contacted us to pay the A past due association or what you owed from the day you bought it. And I have an email now that says, dear Mr. So-and-so, I see you represent this association. I need a ledger, A, and secondly, I need payment information so that I can come current on what I owe you going forward. When you have that, in the worst case scenario, guys, you're going to pay in protest and you're going to sue and they're going to lose every single time. But you got to document these things. And with that, this has been an awesome, I got to say that the online meetings are pretty cool that we get people all around the world, all around the country right now tuning in. Again, a huge thank you to Joy, to Jeremy, and for the class for attending, and any guests that we had from outside, from Facebook or wherever else. I see about 4 people came from completely, I don't even know where, outside sources, but that's awesome. Thanks for tuning in. Guys, if you have any questions, I want Joy, if you're comfortable giving your contact info, and Jeremy, I know Jeremy represents a whole lot more outside third-party bidders, so it may be more beneficial. You guys, if you're comfortable, post it here in the comment section or go ahead and say it out loud now. And I want to take a moment to thank you again. Huge round of applause. Yeah, and Corona fist pumps. You notice, hey, if anyone sees behind me, it's Corona time. Follow my stories on social media about my crazy Corona time tenant who, by the way, just sitting here for this meeting, 29 text messages from Corona time, okay? It's like a crazy ex-girlfriend, and I'm even crazier for allowing her to keep texting me. But you want to give your contact info?
Sure.
Sure. Go ahead, Jeremy. Go ahead.
If you want to call me, my phone number is 561-290-1356. And you can email me at Jeremy, Jeremy, at FLCondoLaw.com.
And what do you specialize in? If you have to summarize in the elevator pitch, what's your specialty?
I specialize in condo and HOA litigation, and particularly I'm very good at these investor issues.
And Joy?
So my contact information is the switchboard phone number where they'll know how to reach me is 954-985-4102. And my email address is the initial of my first name, so K, and then it's MATTINGLY @BeckerLawyers.com. And I specialize in condo and HOA litigation as well, but I manage the firm's collection and foreclosure practice for associations throughout the state of Florida. So I honestly really do just represent associations. We don't take a lot of outside owner work or individual owner work, because we represent so many associations that it's just going to wind up being a conflict at some point. So, but if you have questions, or if you find yourself on an association board who needs legal representation, please feel free to reach out, because we have offices throughout the state of Florida, and that's what we do.
Yeah, we just moved over to them, actually. Woodfield Hunt Club. We're now.
Oh, okay. Yeah.
So they do a great job. They are the best. You guys are blessed to be introduced to two of the top dogs in the industry. If anyone has any final questions in closing, going once, going twice. All right. Well, thank you again. It's been an absolute pleasure having you, and thanks for sharing your knowledge with the group.
Thank you.
Thank you, Mark.
Guys, everybody have
Thank
a
you, guys.
Bye-bye.
Thank you, George.
Thank you.